Attorney General Jeff Sessions boarded a plane for a trip to El Salvador on Thursday where he will meet with local leaders about fighting gang violence. Pablo Martinez Monsiváis, Associated Press. The Department of Justice has filed court papers arguing that a major federal civil rights law does not protect employees from discrimination based on sexual orientation, taking a stand against a decision reached under former President Barack Obama. The department's move to insert itself into the New York case was an uncommon example of top officials in Washington opining directly in the courts on what is an important but essentially private dispute between a worker and his boss over gay rights issues. Civil rights advocates immediately criticized the filing not only for the arguments it advanced but also for having been made on the same day that President Trump announced on Twitter that transgender people would be banned from serving in the military. The department's amicus brief was filed on Wednesday in the Second Circuit Appeals Court in the case of Donald Zarda, a skydiving instructor. In 2010, Mr. Zarda was fired by his employer, a Long Island-based company called Altitude Express. Before taking a female client on a tandem dive, Mr. Zarda told the woman he was gay to assuage any awkwardness that might arise from the fact that he would be tightly strapped to her during the jump. The woman's husband complained to the company, which subsequently fired Mr. Zarda. Mr. Zarda then sued Altitude Express, claiming it had violated Title VII of the 1964 Civil Rights Act, which bars discrimination in the workplace based on race, color, religion, sex or national origin. Under Attorney General Jeff Sessions, the Justice Department has now stepped into the fray, as BuzzFeed reported on Wednesday night. In its court brief, the department noted that every Congress since 1974 has declined to add a sexual orientation provision to Title VII, despite what it called notable changes in societal and cultural attitudes. The brief also claimed that the federal government, as the largest employer in the country, has a substantial and unique interest in the proper interpretation of Title VII. The sole question here is whether, as a matter of law, Title VII reaches sexual orientation discrimination, the brief said. It does not, as has been settled for decades. Any efforts to amend Title VII's scope should be directed to Congress rather than the courts. In 2015, the Equal Employment Opportunity Commission, under Mr. Obama, issued a very different ruling, deciding on a vote of 3 Democrats to 2 Republicans that discrimination on the basis of sexual orientation was illegal. That ruling, which was reviewed by the Obama administration's Justice Department, did not formally bind the federal courts, although courts often defer to federal agencies when they interpret laws.